Okay, so in this video, I want to discuss this real life case of a husband who filed for discharge in a DV case, domestic violence. So I will not spend too much time. Basically, I just want to let this real life example be some kind of a learning that do not go for filing of discharge indiscriminately or recklessly or in a very casual way, because it will only delay your trial, and unless that is your objective, which anyway I would not want to comment on those kind of things. So this is an excerpt from the husband's order, of the basically husband has filed the application under the DV Act and under section 245 of the CRPC. So let me show section 245. Basically, it says that accused, when can he be discharged? And it says, upon taking all the evidence referred to in section 244. Let us have a look at section 244. Basically, it says any warrant case other than a police report. So probably a complaint case. So if we look at the definition of what is a warrant case under CRPC, a warrant case means either offense punishable with death, imprisonment for life, or term exceeding 2 years. And summons case is something which is not either a warrant case or a summons case. Now, why I'm going into all these details a little bit is because I think discharge application as understood under CRPC is not even applicable as per my understanding. But anyway, this word sounds very tempting. So that's the reason probably people go for it. And in fact, I know for a fact that the husband in this case did not want to file a discharge application, but he says that his lawyer strongly advised, and they filed, and it was dismissed. So anyway, let us go to the next steps. So basically, the order of the magistrate court, I am showing some excerpts so as not to disclose too many details about which case it is and protect the privacy of the person. Okay, so it says that contention of the respondents, basically husband is the respondent, has to be decided in a full-fledged trial and not at an initial stage of the proceedings. Now, that's the logic. And now this part of the judgment, basically, it's not worded in a very clear-cut way. I mean, but if you read the basic points, I think it kind of, to find out whether facts emerge from such evidence produced. So it's a kind of a confusing language, but I think the gist is that whether prima facie something is made out or not. And basically the court has held that, yeah, I mean, the language is kind of confusing. The court may, for this limited purpose, sift the evidence as it cannot be expected at such initial stage to accept all that. I mean, on the one hand, evidence is being sifted, but then it says cannot be expected. So why do you want to sift the evidence? Why don't reject it outright? So somewhere the the language is not making too much of a clarity, but then we take what we get and try to understand. And then it says something very interesting at the stage of framing of the charge. Now, framing of the charge is something which happens in a criminal case. And domestic violence case is considered primarily a civil case, except for section 31. I will show that also. This is a Karnataka High Court judgment, and it says that only the breach of protection order or interim protection order constitutes an offense and made punishable. So in general, Domestic Violence Act is not considered a criminal offense, a case under that. And furthermore, it says application under Section 12 of the DV Act itself is not an offense. So basically, that's the reason I showed this definition. The warrant case refers to an offense, and summons case also refers to an offense not being a warrant case. So, but a DV case is not even considered an offense, only violation of a Section 31 protection order. So I hope people got the idea. What I'm trying to say, that a discharge application under Section 245 or 239, whichever section might be used, it is not really an applicable thing. And basically, what people are hoping is that when they file a discharge application, they are seeking a dismissal of the case at a very early stage, basically. So dismissal is something which people seek anyway in the WS or the objections to the main petition filed by the wife also. That's a general thing at the end of the WS filed by the husband, that the petition lacks any merits and liable to be dismissed, etc., etc. So one need not fall for just a term which looks very tempting, that discharge. Let's file for that. It is only going to increase your time in the court, increase the legal costs. And one more thing is, when people go for something which they feel is kind of, they deserve it, and then you don't get it, so it will be a psychological kind of a defeat also, for not for everyone maybe, but for many, because they may have gone with the high hopes and their hopes got belied. So that's one more reason I do not encourage filing unnecessary kind of applications, unnecessary IAs. So just showing the end of the judgment, there is cause of action, etc., etc. The language is again not very kind of a clear-cut language, and so it says that there is sufficient prima facie materials on the record to proceed against the respondents, whereas explanations by the respondents are not trustworthy since not supported by some documents, etc. So this is pretty much the end of that, and after that the court dismisses the application filed by the husband. So I hope this was useful. This judgment by Karnataka High Court, it is a very latest judgment. Probably I'll cover it some other time, just on the topic of offense under DV Act, that it is not a criminal offense. If you want this judgment to be covered, you can put that in the comment. So thanks for watching. Hope it was useful.